Stuart Nash.
Thank you very much, Mr. Chair. That was a great speech from Jenny. It outlines a lot of the problems we face in our society at the moment. Jenny Salisa. What I would like to talk about, Mr. Chair, is sections 107I and 107IAA and 107IAB. Basically, a lot of what we do in society, Mr. Chair, is assessing risk. And the ability to assess risk and make a sound judgment based on that assessment has a very strong determination of where we end up in the actions that are taken. And this isn't just in, this isn't business, this is in life, Mr. Chair. We decide whether we're going to walk home or we're going to have a couple of wines and drink, etc. What this section talks about, Mr. Chair, is the ability to assess risk and what defines high risk and very high risk. Now, Mrs. Salisa talked about the fact there are only 25 to 30 people under these extended supervision orders. I find that very difficult to believe that there are so few people who have committed these crimes. But what we need to do is have a look at this. And what the court must do when it looks to make an extended supervision order following the hearing of an application, I'm talking about section 107I here, is look at a couple of conditions. The first one, Mr. Chair, is the court has to be satisfied that the offender has or has had a pervasive pattern of serious sexual or violent offending. So what we're talking about here, Mr. Chair, is the most insidious people in our society, those who have committed the most heinous crimes. And part of this, though, is the court has to be satisfied there is a high risk that the offender will in future commit a relevant sexual offence, or in fact there is a very high risk. So the bill makes a distinction between high risk and very high risk. And it sets out a series of conditions under which high risk is assessed and very high risk. And I find it a little strange, Mr. Chair, to be honest, that we are talking about people who have committed the most heinous of crimes. I would have thought, Mr. Chair, that all these people fall under very high risk anyway. But let me just go through the differences if you may. I'll seek your indulgence on that. 107IAA, and this is the matters that the court must be satisfied when assessing risk. Okay, now what it talks about is high risk. Then eligible, so this is high risk as opposed to very high risk. A court may determine there is a high risk that an eligible offender will commit a relevant sexual offence only if it is satisfied that the offender displays an intense drive, desire or urge to commit a relevant sexual offence. So again, we're talking about someone that may have a physiological disposition for this. I assume has quite a low mental capacity to assess their own behaviour, let alone what society thinks is right and wrong. In fact, may even have a blurred perception of what is right and wrong anyway. They also have to have a predication for, they've got to be serious sexual offenders. And the third one is have limited self-regulatory capacity, i.e. they do not have the ability, again, to determine the difference between right and wrong, and follows either or the following: a lack of acceptance of the responsibility for past offending and an absence of understanding or for the concern about the impact of their sexual offending on actual or potential victims. Now that's pretty serious, Mr. Chair, I would argue, but that is only the high risk. Believe it or not, there is another category above high risk, and this goes to subclause 2, and this is very high risk. So there is a difference, believe it or not, between high risk and very high risk. Now, the conditions that have to be satisfied for the offender to be very high risk are has a severe disturbance in behavioural functioning established by evidence of each of the following characteristics: intense drive, desires or urges to commit acts of violence, and extreme aggressive volatility, and persistent harbouring of vengeful intentions towards one or more people, and either displays behavioural evidence of clear long-term planning of serious violence offences to meet a premeditated goal, or has limited self-regulatory capacity and displays an absence of understanding or concern about the impact of his or her violence on actual or potential victims. Now, Mr. Chair, I would have thought that people who display the sort of behaviour that is listed in the very high risk would actually be on, what's it called, life.
The member means preventive detention.
Sorry, preventive detention. That's what
I just didn't want to wait too long.
Sorry, Mr. Chair. Mr. Chair?
Stuart
Thank
Nash.
you. Preventive detention, because the sort of behaviour that we're talking about here is the sort of behaviour that, they've done their chips, Mr. Chair. They have committed the most heinous of crimes that our society really, does not accept. This is the sort of crime where you do not get out. We're talking about premeditated...
Where the person does not get out.
When the person does not get out. After how many years? After 24 years, or is it 28 years? 27 years. In the house, in the big house, the really big house. But why, and this is the thing I'm a little bit, and maybe the Minister can help me on this. Why are we looking at extended supervision orders? Why are we looking at extended supervision orders for parole for people who have an absence of understanding or concern about the impact of his or her sexual offending on actual potential victims? Why are we looking at parole, no matter how extended it is, for severe disturbance in behavioural functioning established by evidence of intense drive, desire or urges to commit acts of violence and extreme aggressive volatility and harbouring vengeful intentions towards one or more people, and either displays such clear evidence of antisocial behaviour that basically they are going to commit a crime. This is what this says. And the thing, I suppose, Mr. Chair, that I'm not too sure about is who assesses these. Now, I'm assuming that a trained criminal psychiatrist is the person that comes up with the assessment between high and very high risk. Because I don't know, Mr. Chair, of a court in the land or of a learned member of the judiciary that would have the ability to determine whether someone is high or very high risk. Because the sort of behavioural conditions we're talking about here, Mr. Chair, are those that can only be assessed by a registered and highly trained medical professional. And I was looking through this bill, Mr. Chair, and I could not find the conditions, or I could not find anywhere in here a description of who actually came up with the determination of whether this was high risk or very high risk. But there must be some sort of criterion. I'm assuming, Mr. Chair, before a person like this goes before a court, there is a psychiatrist's report given, and the psychiatrist says, Your Honour, under section 107A11, I deem this person to be of a very high risk. But the thing I have learned, Mr. Chair, is when debating law like this, never make an assumption, because you can often be wrong. So this is the sort of bill that cuts to the heart of what we judge as a civilised society and what we need to weigh up in terms of human rights versus the expectations of communities that they'll be safe. So perhaps if the Minister and the Chair will just enlighten me slightly on who has the ability, or who will have the ability, to assess what constitutes high risk versus very high risk. And the other thing also is, I suppose we get to a certain point where, okay, this person's on extended parole, they're not living with the person from the parole board 24/7. If they are showing such antisocial behaviour, they're obviously doing this 24/7. My real concern is someone out on parole who commits a crime that we're talking about here. There is not only is there a harm to the community, there is massive political risk, and the Minister himself knows this. If someone out on parole who shows this sort of behaviour commits a crime, then, well, we know the sort of stuff that Garth McVicker and his characters will go on about. But, Minister, if you've got any comments to make, I'd love to hear them. And with that, I will sit down. Thank you.